Good afternoon and welcome. Can everybody hear me okay? Good afternoon and welcome to Somebody Call the Doctor, Stitching Up Student Privacy. I'm Kalia Barnes. I'm the Associate Director of the Electronic Privacy Information Center. I'm also the Director of the EPIC Student Privacy Project and a Georgetown Law alum. So I've sat in this room many a times taking an exam. So this is really a wonderful conference, but I must tell you that you are really in for a treat with today's panel. And that is both my biased and unbiased opinion. So biased as someone serving on the program committee for the summit, biased because I'm a moderator, but unbiased because when you read the papers, when you look at the news, when you hear President Obama's announcement in January committing to protecting student privacy, and when Congress puts forth bipartisan legislation to safeguard student records, it's clear that student privacy is one of the leading privacy issues today. More and more, student records include sensitive information, including medical records. So let's just dive right in. I will introduce our distinguished panel. To my left, we have Dale King. Dale King is the Director of the Family Policy Compliance Office, FIPCO, for the U.S. Department of Education. FIPCO administers the Family Educational Rights and Privacy Act, FERPA, for the U.S. Department of Education. Prior to becoming FIPCO Director, Dale served as the Director of Policy, Research, and Evaluation Services within the Department's Office of Vocational and Adult Education. Dale began his federal career in 2001 as a program specialist in the Office of Special Education Programs and also served as a policy analyst in the Office of Special Education and Rehabilitative Services. Dale has over 25 years of experience in education, including being an education specialist with the Tennessee State Department of Education and the Director of Psychological Services for the Hamilton County School District in Chattanooga, Tennessee. It is a pleasure to have Dale on today's panel. Next, we have Cameron Russell, who is the Executive Director of the Center on Law and Information Policy, CLIP, at Fordham Law School in New York. CLIP conducts research and facilitates high-level public discourse on topics such as data privacy and security, peer-to-peer technologies, and intellectual property protection of information assets. In addition to his role with CLIP, Cameron is an adjunct professor of trademark, information privacy, and copyright law courses at Fordham Law School and has been interviewed regarding online privacy issues by various media outlets, including CBS, NBC, and CNN. He has had articles published or forthcoming in the Stanford Technology Law Review, the Berkeley Technology Law Journal, and the Journal of Law and Policy for Information Society. And previously, Cameron practiced law as a partner in the Winder Law Group in New York and worked as a music manager for the then up-and-coming pop star Rihanna. Fun fact. Next to Cameron, we have Dissent. And when Dissent isn't blogging about privacy issues and breaches on pogowasright.org and databreaches.net, she's a licensed psychologist in clinical practice, the author of 2 books for parents and school personnel, and a consulting psychologist to school districts. And finally, we have Bill Fitzgerald, who's a founder of Funny Monkey. Go to funnymonkey.com. Bill has worked in education as an English and history teacher, as an administrator, and a technology director. Bill initially discovered the internet in the mid-90s at the insistence of a student who wouldn't stop talking about it. So I am very pleased to have this wonderful panel with a variety of views, and I'm just going to dive right in. First to Dale. Dale, if you could give us a big picture lay of the land. What protections govern student health records?
Well, looking at it from an education perspective, since I'm really talking about education, and given that I think the directive is I'm supposed to cover HIPAA, FERPA, and HIPAA and FERPA and IDEA within 7 minutes, so we'll see if we can cover that. So let me just sort of give, from an education perspective, I mean, primarily the law, when we talk about education records that pertains to education agencies and institutions, we're talking about FERPA. And I'm assuming, is there anyone in here of the four of you that is a FERPA virgin that doesn't know anything about FERPA? I'm assuming everybody here knows something about it. Well, let me give a very just short, brief overview of that law. And again, we have to remember, it is the primary privacy law governing the protection of education records in schools. And basically, FERPA is really simple at its core. I mean, it really does basically three things. It gives parents rights. It really is providing parents the right to inspect and review their child's education records. It gives them a right to seek to amend those records. It provides that the parent must give consent before any of those records are disclosed to any third party or any outside entity. And it gives parents then a right to file a complaint if they feel like their rights have been violated, and they can file that complaint with their office. So at its core, it's pretty simple. Now, of course, it does get a little bit more complex. Now, you have to remember that FERPA only applies to educational agencies and institutions that receive federal education funds for any program administered by the Secretary of Education. So there are some entities that FERPA does not apply to because they don't receive those funds. But in general, that's who it applies to. And then, of course, there's the key definition. It's talking about the protection of education records. Now, statute itself is very broad. It defines an education record as being, if it specifically pertains to an individual student, and it's being maintained by that educational agency or institution. So it's a very broad definition. Now, when Congress passed it, they did recognize there are certain types of information, and this will probably come up today, that is not really considered to be an education record, and that's like sole possession. We call them sole possession records. Treatment records is another one that's not really considered to be an education record. But treatment records is a term of art under FERPA, and some people I know get that confused. And there are a few others that are not considered to be education records, but I'm not going to really go into those since I do have the 7-minute limit here. Now, as I said, parents have to consent. This is really the easy part of FERPA. Parents have to consent. As we said, that you can't disclose. However, under FERPA, you have to remember that there are certain statutory provisions that permit an entity or a school or an LEA to disclose if it meets one of what we call the exceptions to that written consent. And there are several exceptions under FERPA, and this is where it really gets muddy, and it really gets more complex, and we deal with it. But for example, one is they can disclose to other school officials without having to get consent, and that makes sense. Schools could not function if they had to get consent every time they were to disclose to another entity within the school. So that is one of the exceptions. There's for health and safety emergency is another exception. And again, a subpoena, litigation. That's another type of exception where you do not have to get the consent of the parent before you disclose. And also remember that under FERPA, once a student turns 18 or enters post-secondary, all these rights we were talking about transfer to the student. So they no longer belong to the parent, they belong to the student. Now, one thing to remember about all these exceptions I've been talking about so far, and there are numerous of them, all the exceptions, they're permissive. Schools are not required to disclose, even under a subpoena. It's not the subpoena that compels a school to disclose. It's because generally people don't look good in orange jumpsuits and stripes. It's the fact that the courts is really compelling them. It's not FERPA. It's still permissive. Now, another, which people don't really think about, but IDEA, the Individuals with Disabilities Education Act, is another education law, that really also has its own privacy provisions. Now, in general, they usually just cross-reference to FERPA. However, there are some differences in the IDEA. Now, IDEA only pertains to K through 12, not post-secondary. But there are some differences in the IDEA provisions around their confidentiality. So just to keep that in mind, I'm not going to really go into those unless people have questions about it. And then the last thing was just a little briefly, just the HIPAA, FERPA. Oh, yeah.
Can I just clarify about the age of students or families that are covered by FERPA? Do the parents hold the sole ability to consent? Like, say you have a 17-year-old high school kid who's not yet 18. Mm-hmm. Do they have any rights under FERPA, or do they not? to
Well,
their own data, for example?
they can't consent. They can't, I mean, you can give students certain, we have sort of said that, for example, if you have a 17-year-old, that the school could choose to allow that student to have access to their records.
So there's discretion on the part of the
That, but you can't, what you can't do is you can't take away the parents' rights.
Right, they could have joint rights.
Yeah, but if you're talking about signing to disclose, that would be the parent. The parent could only do that. The student cannot. If the student is not of legal age and the parent is still a parent of the student, then they cannot. They could not. The student cannot consent to the disclosure.
But they can give away their own information.
If the student, yeah, we've had that happen. The student has, if they have a copy of their records and they choose to give it to someone, then it only pertains to what the school does, not what a student may do or a parent may do. Quickly on the HIPAA, FERPA, and then we'll move on. I think DeSantis is also going to talk a little bit about that. But under the HIPAA, FERPA, and again, my office doesn't administer HIPAA. Just understand that. We only deal with FERPA, and really only FERPA. We don't even deal with the IDEA. That's in another office. But under the HIPAA privacy rule, what is generally, when we're talking about the interplay between HIPAA and FERPA, the bottom line is if it is an educational agency or institution that is subject to FERPA, then the records, whether they're health records or whatever, that are being maintained at that school are considered to be education records, and they're not subject to HIPAA. Even if it's a HIPAA-covered entity, like at the post-secondary level, they may have a clinic, a health clinic. And even though it may be, the health clinic, may be subject to HIPAA, and they do transactions, et cetera, but even if it's a school clinic, then the health records that are being maintained by that clinic are really education records. They're covered as an education record and not either an education record or a treatment record under FERPA and not subject to the HIPAA rule, privacy rule. So that's, it's the bottom line, and it gets into really intricacies on that, and there may be questions that come up. But that's sort of the bottom line around the HIPAA, FERPA, is if it's not subject to both. It's either going to be covered under HIPAA or it's going to be covered under FERPA. But it's not both. And so I think I'm going to stop.
That's wonderful. Thank you very much, Dale, for handling the yeoman's task of explaining student privacy, what laws govern. One of the points that you made, and I think sometimes that gets lost, is that FERPA is permissive but not mandatory. And oftentimes it seems the stories that we hear are that schools are just giving it away as if giving student information away as if it is something mandated by Congress. And I know that dissent has seen practices in school about schools just giving it away as if they're forced to, or just practicing poor data practices. So if you could just tell us some of the things that you've seen.
Well, yeah, because I do wear two hats. If I'm sitting in my office doing something, like if I create a report on a patient, we'll call this the report on my patient, I'm a HIPAA-covered entity. And I'm going to have this, if I have to email it or transmit it, it's going to be encrypted. My hard disk drive is encrypted, all kinds of technical and physical safeguards as per HIPAA. But if my patient's parents come to me and say, Dr. Doe, Jeannie's school doesn't understand her. We want your report to go to the school so that the teachers understand her symptoms and her diagnoses, and she's no longer punished for the symptoms of her disability that the school doesn't understand. So here's this report with all this medical and sensitive and psychological information, and it goes to the school. Cameron's the school here. And as soon as it does that, it's no longer protected by HIPAA. That is now an education record. And it's under FERPA. It's no longer under HIPAA. So real world, what happens is the school, and again, in some cases, I'm working as a consultant to the school district. So it's not my patient. It may be a student I'm working with. School personnel may want to email me about a student and their diagnoses and the behavioral problems and whatever. In fact, last night I got back to my room and there's an email from a client school district. I won't name them or shame them, but it's typical of what goes on. I have not found a single school district in this country that uses encryption for email. If anybody knows of a school district using encryption for email, please let me know. I'd love to blog about them and give them a public thumbs up. But what the school personnel do when they want to talk to me about a student, whether it's my patient or a student in my consulting work, is they want to make sure it doesn't go to my spam filter. So they put the student's name in the subject line. All right? So here's this email with the student's name in the subject line, and this is under FERPA. Remember, this is not under HIPAA. And all this information in the body of the email, or maybe there's a form attached that shows their special education services that they're getting, like occupational therapy, physical therapy, counseling, whatever. This is standard. I'm not the only one reporting it, but I think people need to understand that the same information that would be protected under HIPAA in one setting comes into the school, and it's like the protections aren't there. It's like man-in-the-middle attack. What's that? Encryption? We don't need to do that. And there's nothing in FERPA that requires schools to do any of it. The U.S. Education Department has made recommendations to schools, and they've offered guidance, but there's nothing that actually requires it. So the physical and technical safeguards that we have with HIPAA, while they're not ideal, I think most of us can agree on that, they're a heck of a lot better than what I see under FERPA on a real-world day-to-day basis. But if we even look at what happens if something goes wrong, if there's a breach, what are the rights of the parents, what are the rights of the students, what are the rights of our patients? If there's a breach under HIPAA, we have a duty to notify. We have a duty to notify HHS, and we have a duty to notify, in most cases, the patient themselves. We may also have a duty to notify the state, depending on what the state law is. What happens under FERPA if there's a breach? A school district, I'm going to talk about K-12 because it's a little bit different when we get to post-secondary. At the K-12 level, there is no duty to notify the U.S. Education Department of a breach. The U.S. Education Department does not collect information on data security breaches. A district has an obligation under FERPA to keep a record of disclosures of information, and that would include an accidental disclosure. So if the student or their parent knows at some point to file under FERPA and ask the district, by the way, I'd like to see everybody or every place you've disclosed my information to, they will find out that their information has been in a breach. Other than that, the school does not have to tell them. In some cases, school districts may have to disclose data security breaches under state law, but that is not that common because there's only about 7 states, I think, maybe one or two more now, but about 7 states that require breach notification if the breach is in paper format. Most breach data notification laws relate to electronic data, not paper records. So everything is much weaker when we start talking about the protections for students' education records and when we talk about what happens in the event of a breach. And as Dale explained very well, students' health records, their medical records, are not considered anything other than education records at the K-12 level. FERPA does have something called a treatment record, and that's a record that is used only to treat the student. But treatment of students doesn't mean what we think it means. School counseling, school psychological services for a student, that's not treatment. Even if it's a clinical service, speech pathology is not treatment. Those are educational services. Those are related services. So they're not considered treatment records. They're still considered educational records. And if you, how many of you, has anybody here ever gone to an IEP meeting? Okay, if you don't know what one is, you probably haven't been to one. But an IEP meeting is an administrative proceeding at a district that involves teachers, administrators, service providers, where they get together and talk about what a student needs. And they review the student's occupational therapy testing, physical therapy testing, IQ testing, everything else. So you have 10 to 20 people sitting around a table with a stack of reports. And they're going to review these reports and decide, does the student need special education services? If so, what services and with what frequency? And what will the goals be? And at the end of the meeting, everybody gets up and leaves. And what I see a lot is people get up and walk out with those reports. They're not collected back. So remember that wonderfully sensitive report I handed to Cameron on my patient? That included their diagnoses, their symptoms, their medications, and since most of my patients have disorders that are genetically linked, a bit of their family history as well. That report just walked out of the meeting. and nobody knows where it's going to wind up, on a kitchen table somewhere, on somebody's home desk. So I do have, as a healthcare professional and as a student advocate, which I've also been for a disability organization for the last 30 years or so, I have a lot of concerns about FERPA and even IDEA. If you look at IDEA, and it's like 300 some odd pages, I think, that law. If you look, search it for privacy, the word only shows up twice, I think, in the whole statute, something like that. If you have a complaint under IDEA, you have to go to your state education department. You have no private cause of action under IDEA. You have no private cause of action under FERPA. You have no private cause of action under HIPAA, as you all know. So basically, our students are screwed, whether they're our patients or whether they're our students. When it comes to their rights, they're screwed. And enforcement is also, I'll finish up with enforcement. Can I take a minute to talk enforcement?
Please.
Okay. Enforcement also makes me crazy. Most of you know what enforcement is like under HIPAA. HHS will work in an educative way first to try and correct a problem if they become aware of a problem with physical or technical safeguards. If they cannot resolve it that way, they'll go to a consent order. They also have the option, in some cases, they can go to a civil penalty, or they can even go for criminal prosecution. So HHS has a number of options on enforcement. HHS also gets breach reports because the law mandates that we report breaches to HHS. But what happens with student privacy, with student health records that are under FERPA? FERPA does not require districts to report breaches to the U.S. Education Department. So what does the U.S. Education Department know, and how is it going to enforce? A few years ago, I had collected, on one of my blogs, I had collected about 140 breaches from the K-12 sector based on media reports. I compile breaches and I research breaches. I said, gee, let's find out what the U.S. Education Department knows. So I filed under the Freedom of Information Act with the U.S. Education Department, and they were lovely. They sent me a CD. I got very excited when I saw the CD. I said, oh my God, they've got data, and I love data. I plugged the CD in my laptop, and there is not a single one of the breaches that I knew about that is in their records. Not a single breach. I have 140 breaches. None of them, the only breaches they knew about, none of them came from K-12 districts. They only came from another agency that dealt with student financial aid that had breaches in mailing and things like that. So the U.S. Education Department is pretty much in the dark, according to their own records. Their enforcement options are very limited. I mean, they do have the option to cut off all federal funds to an entity that has violated FERPA. To my knowledge, they have never done that, and I can't imagine them ever doing it. So that's another way in which FERPA is weaker than HIPAA. Neither law is ideal, don't get me wrong. I don't want to pit one against the other totally, but I'm just saying, as bad as HIPAA is, in my honest opinion, with all due respect to Dale here, FERPA is worse if we're really trying to protect student privacy. So there's, Kalia mentioned that there's all these bills that have been proposed this year on revamping FERPA. There's good stuff in all the bills, but I think one of the things that I would encourage people to look at is take a close look and see what they're doing with the health records, and if they're going to offer them more protection, because they're silent on that point. And I think if we're going to revamp FERPA, this is the time for us to recognize that some data is more sensitive than others, and it needs a higher level of physical and technical security and other breach notification methods if it's breached. Anyway, I went past my 7 minutes. I apologize. My rant is over for now. But I'll be happy to answer questions if you have.
Thank you very much, Jason. We really appreciate that, especially the emphasis on security and the proposals going forward to include medical information and enforcement or lack thereof. I would now like to turn to Cameron, and for those who have been following student privacy closely, you really can't get into student privacy without hearing something from Fordham Clip. Fordham Clip provides empirical research on student privacy, what's happening in schools, and more importantly, like what's not happening in schools and what needs to happen. So Cameron, if you could take a few minutes to tell us about Fordham Clip's report.
Sure. So we released a study in December of 2013, Cloud Privacy and Cloud Computing in Public Schools. So the scope, the extent to which public schools were using cloud services. Previous to our 2013 study, we knew districts were increasingly using cloud services, but we didn't have any hard data. So how are the cloud services actually being used? How much are they being used? What types of contracts are in place with private cloud vendors? What types of student info is being transferred? What types of services what types of cloud services are being used? So our study was the first empirical study that we know of that showed a national picture of how districts are addressing use of cloud services. So we were we specifically did not target individual districts for a compliance audit of that sort. We were really looking to just see a national picture, a national aggregate picture of these cloud services. So you also heard from Dale the big picture, the legal landscape, and educational privacy. So who the actors are important, right? And the types of info within the sectoral privacy scheme here in the U.S. That the actor may be important, the information type may be important, the technological architecture is important. So the existing law may not apply to the actor or the information type. So as Dissent was discussing, it may not be covered by either HIPAA or FERPA. So the goals of the study were threefold. As I mentioned, provide this national picture, general assessment, assess how the contracts, the documents that we were able to provide through Open Records Act requests match with the statutory requirements in educational privacy. So we did kind of a checklist, a statutory checklist, which is at the back of our 2013 report. I think it's a fantastic resource. It's on our website, open source, so feel free to reference it. And also generally accepted accounting principles. And provide a set of recommendations and resources. So I think I can mention that at the end of the resources, the additional resources that we have available. So we found general findings. We found that 95% of districts within our data set are outsourcing student information to the cloud. And we had a diverse sample set. So we did large districts, small districts, urban districts, rural districts, from every geographic region in the country, and 95% of this set of districts were outsourcing data to the cloud. That transferred student information included school records, homework essays, what did I do on my summer vacation, which may include some really personal things, fitness profiles of students, and even lunchroom purchases. So these were just a sample of the types of cloud services that were being used by districts. We also found that there was a wide diversity of cloud services across every type of school. So using cloud services for data analytics, student reporting, guidance functions, what we called special school functions. So this may be the lunchroom purchase or bus transportation services, hosting services, maintenance, backup, classroom functions. Of course, teachers are always looking for fantastic new ways to be more dynamic in the classroom, as they should be and commended to do, but using private cloud services to improve the classroom experience may not fall under an educational record under FERPA. We also, lastly, based upon the documents, so this was law students and lawyers reviewing what documents say. We call these unidentifiable functions. So from reading the document, we couldn't figure out what the service is that's actually being provided. It's a boilerplate legal contract, but it doesn't go into any depth. So a parent who did an open records request would have no idea what exactly this service is. So this was very alarming because 25%, a quarter of all agreements that we received were for unidentifiable services. We also found that there was weak transparency. So in doing this research, we tried to stand in the shoes of a parent and say, what could the parent know, even if using Open Records Act requests. We also did public sweeps of websites. So often school districts will post their policies, acceptable use policies, and you'll be able to see that they're using a portal. They could be using Blackboard, a portal. You can see the portal there from the website, but you might not be able to see the underlying agreement between the district and the service. You may be able to see a general terms of use or privacy policy from the website, but that may contradict the terms of the agreement with the district. We found that districts failed to respond to public records requests even if we sent them. Districts often didn't provide parental notice as to the existence of cloud relationships or the types of information transferred to the cloud service providers. As Dale mentioned, FERPA generally requires notice to parents and consent for certain disclosures and a parental right of access. So this is another transparency issue for parents. It's also an issue for districts to comply with their FERPA obligations to provide a right of access. If they're not imposing these obligations upon the third-party vendor, which of course FERPA doesn't directly apply to, then how are they supposed to force the right of access for the parent to actually exercise that right? We found at times there was an ignorance of the district's use of technologies. I don't mean that in a derogatory way, but they would respond to our request, we don't use any cloud services, and then you would see the portal doing the public web suite that wasn't in fact true. We also saw weak data governance and contracting practices. So 20% of the districts in our research had no policies addressing teacher use of IT. So this is, of course, the teacher's trying to do the best job that he or she can do, wants to make the classroom a dynamic place, but kind of going rogue with getting a third-party cloud service and asking the kids to download it without any prohibition or vetting by the district and the school in terms of having a policy that they can't do that without some type of procedure. We also found some agreements where the vendor could unilaterally modify the agreement without any notice, which of course is common practice in online web and privacy policies, but in terms of FERPA obligations, it's not a good governance practice. We also found that even if school districts had an agreement with a district, with a vendor, the parent may have to go online and activate the service on behalf of the student so that they could use it, which may contradict whatever that agreement was. They could have contradictory terms with vis-a-vis the parent that they're contradicting the agreement that the district had with the vendor. A few agreements gave districts a right to audit and to verify vendor compliance, even if they did have an agreement that imposed obligations indirectly, that they're FERPA obligations of the district indirectly upon the vendor. Many vendors were not prohibited by contract from redisclosing the data, so even if it's under the school officials exception, there's no prohibition on redisclosure, which is certainly an issue. Also a direct control problem for the district. And often, and the dissent talks about data breaches, there's often nothing in the contract regarding security. Okay, so security is always a moving target, whether you're going to have NIST requirements or whatever it is, but there was often nothing in the agreement with the vendor regarding security. And fewer than 7% of the contracts restricted the sale or marketing of student information by vendors. So a lot of this legislation pending, discussed. This component is this at least a prohibition on commercial use, freemium services. So of course these are not free services. They're monetarily free, but you're in essence paying with the student's privacy for these services. So we found in our study that over 25% of the cloud services being used were for classroom functions were being offered for free. So these are 25% of the classroom functions services being used were freemium services. So in essence, advertiser-supported services. So there's many more nuanced issues. You can reference our 2013 report. But if I have time, please also ask that I talk very, very briefly about a report we also did in 2009. So of course this is a little dated at this point, but this was regarding state reporting systems, longitudinal database systems from K through 12 schools to state departments of education. But at that time, it was clear that these longitudinal systems were being used to gather health information and report it to states. There were specific instances of states recording children's pregnancies, mental health, and illnesses, but very few states were spelling out exactly, for the public, exactly what records are being provided, and not clear at all what the scope and what the data points were that were collected and provided to states. So our research helps to paint the topic of the panel was state of student health data. It helps to paint a national picture as to the scope of collection, use, sharing, retention of student health data and student information generally, and how these jive with existing legal regimes. So lastly, I'll just say we did have a set of recommendations in both the 2009 and the 2013 reports. They're available on our website. We also have a package of open source resources for school communities to use, for parents to use, for school districts to use, for principals to have a dialogue with their teachers. These are handbooks, checklists that can be used to verify, to compare a vendor contract that's proposed versus statutory requirements. Also, model contract language that others are free to use. And these are, again, as I mentioned, all free, and I encourage you to reference them and use them on our website.
Absolutely. Thank you so much, Cameron. CLIP has a wealth of information, and they really have been instrumental in painting a clear picture about what's happening. Oftentimes in the privacy community, you can be accused of, oh, the sky is falling, or let me tell you this one horror story. But what CLIP did is, no, this is a systematic problem that students are facing. So those were both incredibly important reports. And last but certainly not least, we have Bill from Funny Monkey. Funny name, but very serious about student privacy. And so, Bill, if you can explain to us what Funny Monkey does, how it works with schools, vendors, its advocacy role. I know there was a mention of E-rate, if you can expound upon that.
Well, yeah, so I mean, we've been working as an open source development shop with a range of clients for the last decade. And we've done a lot of privacy work and advocacy around what we've seen. And a lot of it overlaps pretty significantly with what the other people have already spoken about. But our focus really falls on what gets left out and what falls through the cracks in terms of what's covered by statute and what's actually happening in practice. And when the CLIP report came out, that was actually an incredibly useful resource because it quantified in a way that other things hadn't exactly how weak things were. What was also actually interesting in that report was the number of districts who were approached for information and who either chose not to respond or weren't able to respond, which I actually think is more typical. I actually suspect that what you were able to quantify was a rosy, optimistic view based on what's actually out there. Particularly when it comes to issues of contracting and people within a district actually knowing what they've agreed to. Because most of these agreements are click-wrapped, which basically means you don't actually get a copy of it. You check the box that says, I have read these terms and conditions. You click submit, and that's it. So then you need to actually be able to go back and find that over time. So as part of our work, we've actually done direct outreach to vendors and some kind of awareness raising with parents and other stakeholders about things to look for and things to avoid, or things either to do well or things to avoid. And the ability of a vendor, for example, to notify their terms to modify their terms without notice should really be a deal breaker, but it's not. And that's a very common practice among a lot of vendors. But one example that I think shows some of the issues that are at play here is actually Google Apps for Education. And I'm using Google as an example, not because they're Google, but actually because they actually they're A, a recognizable name, and B, they're pretty representative of how things work across the industry. Their apps for education, their terms of service specify that they will not use data collected within their core suite of apps, Gmail, Calendar, Hangouts, Google Classroom, Google Vault, for what they call ads purposes. They say that they will not display ads, but they never really define what ads purposes is. So there's that very gray area at the outset. But then in a separate part of their policy, they also reference additional services that appear in the admin panel but aren't part of the core Google Apps suite. But they have no link to what that is. until down in section 16. So section 1, they say we don't do ads purposes. Section 2, they say, well, there's these non-core apps that are also applicable here. And then in section 16, where they go through definitions, they have 50 definitions, including non-core apps. But they don't even define it there. They link to a non-core apps page that lists things like Blogger, things like YouTube, things like web history, commonly used tools in schools. And then, but they don't even say what happens there. They just say these things are non-core apps, and there's a link to another page that specifies any information we get in these non-core apps can be used for commercial purposes. So you have the core apps, which in one way can be understood as really a funnel for collecting this information. And this gets to what Dissent was talking about, where you have information shared within these systems that is incredibly sensitive. And the line between what's an educational record and what is a health record is a blurry line in a school setting anyways. Like when you, as a teacher, are interacting with a kid and you ask about, what's going on, and like they say, well, I've been having X issue. If X issue is a mental health issue, if X issue is a physical health issue, that's a learning issue and that's a health record. A teacher isn't necessarily a teacher isn't a medical professional, but the information is very comparable and in some cases indistinguishable. So when you have these interactions which exist in a legal gray area, certainly on the floor it exists in a practical gray area and are not protected in any meaningful way by terms of service, and can then be distributed more or less ad infinitum without any consent from students at the discretion of a vendor that you will actually never really meet. It's very difficult to say that protection for student data and for student privacy is adequate. And it's those gaps are the ones that we're trying to fill. One of the things that's often absent, actually not even often, always absent, from student privacy conversations is the notion of student or learner agency. And we alluded to this a little bit before, but if we start talking about building these systems with an eye towards creating a means for kids to actually go in and learn from and look at their data, learn from and look at their records, the notion of privacy shifts. Because at that point we have an informed subject, an informed person interacting with their information, their record, not an observed object being essentially having this record used to kind of shape their experience. It's a different frame. The legal framework doesn't really exist for this in any way, shape, or form, but it's something that's missing from the larger conversation that I think has a place within the legal framework.
Absolutely. Thank
Really
you.
empowering.
I agree with Bill's point, and as Sen is saying, it's very empowering. When I think about student and learner agency in this space, I'm also thinking when we talk about student privacy, about the intellectual freedom aspect of it, and for the student to say, I'm having difficulty in this, I need a speech pathologist, I need to have these types of services without the fear that will then come back and be used against her. So that's one of the things that I always, yes.
Yes, well, and that's, a lot of the current legislation is focused on tailored ads. And tailored ads is a very real concern, but they are also the tip of the iceberg. Until somebody can really adequately explain the difference between learning analytics and profiling, and until we can actually explain how we keep confirmation bias out of our data analysis, we have much bigger problems or additional problems that go far beyond tailored advertising.
Absolutely. So with that, I have a question about open records law and privacy, but really at this point I'd want to open it up first to the audience to see if they have any questions before I dive in.
Yeah. A couple of you mentioned treatment records and FERPA, but nobody said what they were and how they're well, maybe you did, but
No, well, I can answer that. I think
So we talked about how most of the educational records are not treatment records, but or examples of things that you might think are treatment records and FOIA. So what are they and what protections?
Well,
or what,
treatment records is a term of art under FERPA. And it was specific when Congress initiated or passed FERPA, they basically identified these certain types of information that are not considered to be an education record. And one of those was what's called treatment records. Now, treatment records, when Congress said it, they were talking about like a psychiatrist or psychologist, their notes and their information that they maintain on that student, that it's only for their eyes only, they only maintain it. So it's not going to be disclosed to anyone. It can't be disclosed to anyone else. It's only for that treatment provider's use, or if it's disclosed to another treatment provider that's providing the services. Congress did this basically because they didn't want the student to have access to them, because if it was considered an education records, then the students would have all the rights to access, review, etc. So they carved out this what's called treatment records under FERPA, and it only pertains at the post-secondary level. Treatment records are not really considered. I mean, under FERPA, there is no such thing as a treatment record at the K-12 unless it happened to be a student who's 18, possibly, but general.
The school psychologist, this is what you were saying. You go see the school psychologist on a regular basis, and that psychologist has treatment notes, or what under HIPAA we might call psychotherapist notes.
Right.
Those are education records.
Those are education records at
So
K-12 for
if I'm a
sure.
student, I
Right.
can get access to them, and so can the parents.
At the K-12 level,
At the K-12.
the parents could, because at the K-12 level, all of that information, if the psychiatrist is maintaining those at the K-12 level, then those records, there's no such thing as a treatment record under FERPA. Those are education records. So under FERPA, those records that are at the K-12 level, if you have a school psychologist who has records on that student, those are all considered to be education records.
Minor has access to
And
In actuality, school psychologists will generally not disclose those records for the very reasons you're imagining. Test protocols, they do not have to disclose under FERPA either. But there is some information that they do have to share. And again, it's not all for treatment, because the information that the psychologist is doing, if they're providing counseling like anxiety reduction techniques or self-management, dealing with impulsive behaviors, that's in service of helping the student benefit from their free appropriate public education program. It's used in support of the educational service.
Right, so then someone also mentioned, and this is where it's tied together, that FERPA is essentially discretionary, but it's not discretionary with respect to...
I need to clarify that.
His or her own records, right?
FERPA is not discretionary.
Right.
FERPA, I mean, if a school or if they receive funds, there are the exceptions to consent that are discretionary.
So what, I understand, but there's no discretion about a student or parent getting the student's own record. That's a right. Is that correct? There might be exceptions, but it's a right to get access to your own record. And so if these counseling records are education records, the student or parent may have access at the K through 12 level. Is that right? Okay, that's what I want to
On some level, yeah, which is another reason, too, that we need to be careful sometimes what we put. But that's true even in regular clinical practice. The patient may have a right to access their records or access.
They don't have the right to access psychotherapist notes.
No, not psychotherapist notes, but other records, too. So what do you put in your records? You know, how much do you keep in your head and how much do you document?
Not records. You
What?
don't have to keep them separate. If they're segregated, you may segregate them. And if you segregate them, you may withhold them. But if they are integrated as a record,
What's underlying your question, though? Because I think what's your concern?
So a couple of friends of mine came to me recently this week and have asked me, one who has a 17-year-old high school student, and one who has a student who has some disabilities and who is in college, and who did not get notified that the kid was having trouble as a parent of a student with disabilities, and is concerned about how that's not working. And so I'm trying to figure out for them, well,
at the post-secondary level, things are a little bit different. Dale, I don't know if you want to comment on that, but it's a little bit different about notifying parents at the post-secondary level.
Right. So I have two different ages and two different contexts, and I'm sort of trying to
Well, at the K-12 level, in that situation, those would be considered, education record, and the parent would be able to access. Now, if you're talking about under FERPA, there is what's called a sole possession. So whether a psychotherapist's individual notes could possibly be considered as long to be sole possession, and that means as long as they're not disclosed with another person. But if they're commingled with, if those notes become commingled with the education record, then they're an education record.
Right.
Now, at the post-secondary level, in terms of the parent who says, well, she didn't know. I mean, that her student, if you have a student, it's at the post-secondary level, all those rights belong to the student. However, there is an exception under FERPA that would permit the school, the post-secondary institution, to disclose to the parent the education records on the student, as long as, I mean, we didn't even have to inform the student or get the student's consent, as long as that student is still considered to be a dependent for IRS purposes. So if the student is considered to be under, the parent is carried for IRS purposes, then the school can disclose to that parent.
And they can disclose problems with alcohol, depression,
Exactly.
anything that can be a concern. After the Virginia Tech massacre in 2007, parents started asking again, can't the school let us know? Why aren't we being told certain things? There have been a number of student suicides. So one of the things that happened, I think, was that they clarified that, yes, even at the post-secondary level, even if the student's 18, that certain information can be disclosed to parents for public safety and other kinds of
But it's
issues.
still discretion.
Yeah.
Well, I think these questions speak to a common problem from the American Psychological Association. We see a lot of both professionals who work in school settings and families and students don't understand and aren't really aware, and
Right.
when they're admitted to college, these differences aren't explained. So you go to a college counseling center and you talk about maybe sexual assault and things like that, and you don't understand some of the limitations of confidentiality, all these different issues. Parents don't understand that they may learn very little about these issues, or providers who work in these settings may not really understand this. And I know the question really is, at policy level now, there's some mental health legislation that's considering changing both FERPA and HIPAA and expanding families' access to information about serious mental illness. I think with the idea that it could be helpful to have families more engaged with treatment, but on the other hand, sometimes it's the families that are the issue, with incest and things like that. Do you have any thoughts about, potential improvements? In Oregon, there was a disclosure of
Bill's from Oregon, so
sexual assault issues. It's a very confusing space, as we've seen. So I don't know if you have thoughts on these different sort of problems and legislative remedies or potential remedies.
Well, there are going to be people on the panel who have a lot broader take on this than I will, but just an initial observation, I don't think people understand their rights under FERPA, period, at the K-12 level, at the higher ed level. I think the process for actually initiating a FERPA review within a district is going to be beyond the reach of parents without a large amount of time to wade through that bureaucracy. The way the law is written, the district can actually specify the time and place where a parent can review the records. And if the parent asks for, and again, there could be a cost for printing out these records that the family would need to bear if they can't make that time and place. There are a series of bureaucratic hurdles that impede people's ability to access their legally guaranteed rights that could and should be eliminated to make it possible for people to access these rights more readily. But again, it's going to be a much greater depth of opinion than that, but that's an initial observation.
Okay, I'm going to wear my hat as Dr. Doe for a moment, if you'll permit me. I'm not as concerned about the access as I am about protecting the confidentiality of the mental health records. At the college level, the cases, Oregon they had 2 cases at the university and a third one at OSU. I mean, I don't know why it's all happening in that state, but it certainly is an issue. If we want the patients to come to us and be able to share the information, they have to know that it's not going to go out to 60,000 school officials, and they don't even know who those officials are or for what purpose. I started this by saying that the best reason to come to this workshop, this panel today, was if you're a parent. To know, because I think it's quite true. Parents don't understand. I think under FERPA, the districts and the colleges have an affirmative obligation to explain this and to provide notice. I don't think they do a good job. I think most parents are absolutely in the dark and would have no idea that a school psychologist has any different obligations or any different rules about their records than a private psychologist would have. I think the parents who come to me and ask me to send a report to their child's school, the first thing I do is I say, I have to explain to you what's going to happen. So that if you want me to do it, I'll do it, but you have to know the risks that you're taking with this information getting out there and being all over the damn place.
Well,
So I am concerned about that.
Well, I mean, I agree that probably, even though under the law they're required to annually inform parents and students, if they're eligible students, of their rights under FERPA. And, I mean, that's the requirement. Now, I agree that probably, even though that's what they're required to do, that the parents don't necessarily read and totally understand, that students don't read and totally understand. I think that is an issue. I think that's a place where schools and institutions can do a much better job. But again, if we're talking about legally, they're meeting the legal requirement if they're doing that. In terms of I think that we all agree, and I'm not disagreeing. I think that there's information that's highly sensitive. I mean, if you're talking about students' person or their treatment record, if they're talking about their evaluations, their counseling records, that's highly sensitive information, and I would agree that should be protected, and schools should not disclose it, and should maintain it as much as possible. Now, I don't think that even under the current law, I understand that is still protected. If they were going to disclose it, they can't disclose it to all 600 school officials. I mean, it can only be disclosed, any information, whether it's treatment, whether it's their treatment records or whether it's their scores, test scores. It can only be disclosed to those school officials who have a legitimate educational interest. Now, granted, that schools, they determine that is, but it's got to be somebody. We've usually said it's got to be somebody who needs to know that information in order to do their job. So anyway, but I agree that there needs to be better.
Let's go back to
I'm sorry.
PPRA for a second.
Before we go back to PPRA for a second, because I know they have us on a tight schedule, so I want to officially end the panel. However, I know our panelists will be around to take a few questions afterwards. There are other panels that people are, but I want to thank very much each and every panelist that I have here. This has been a wonderful panel.
Now can I mention PPRA?
By all means.
There's another federal law you need to know about. It's called PPRA. And what it does is it took some of the most sensitive data, and there's 7 data types that are included under PPRA. This is a standalone law. And it includes a student's political affiliation, mental and psychological problems, sex behavior and attitudes. Does this sound familiar, folks? Illegal, antisocial, self-incriminating, and demeaning behavior, legally recognized privileged relationships, and income. If a district wants to do a survey that's going to tap into those kinds of data, under PPRA, they're required by law that the school or the contractor doing the survey get written opt-in consent, written parental consent for the student to participate in that survey. If, and here's the if, you ready? If the survey is funded by the education department. So if it's a federally funded survey, and there's something called the PRIDE survey, you can look it up online. It's a national survey that's looking at some of these issues, and they have some samples of what they're doing in different states. They need to get written consent of the parent. But what if it's not federally funded? What if a district just decides to do a survey like this without federal funding? What protects those data? Are they education records? What are they?
Well, but those data are also relatively anonymous, though.
Well, they're supposed to be, but in a small district, if you can't figure out who it is, I mean, that's another issue. Anyway, I just wanted to throw that out as another problem for us to look at and think about wrapping into any FERPA rewrites or redos.
Absolutely.
Can I just ask a question? I think that this all sounds really interesting, and a lot of it sounds really shocking in like a theoretical way, and in the way you said, like, well, what if, and talking about the way records can be used against somebody. Has that happened? Are there examples where your records have been used against you, where there's been just egregious abuses of health data in educational planning programs? are we talking about this more?
That's a great question because I'm actually looking to start collecting data on that myself through my blog. I'm going to be asking for specific examples of health data breaches being used against a student at some level.
Well, I just mean like the example you gave about the people leaving the data, and just walking home with it. I mean, I think that sounds awful, but I also know like that also could happen with a doctor, right? I mean, doctors take charts home all the time, and I just don't know.
Right, I know.
Is this systemic? Is this a theoretical problem? Or
No, it's not. I know of a case, like, for example, where teachers know students' diagnoses, and a parent was complaining about a student, and the teacher decided to disclose the other student's diagnoses as a way of explaining why the student was having behavioral problems.
Well, and one other thing, too, is, you don't really need to look very far to see examples of pervasive bias based on data being used in society at large. Prince Henry County saw discrimination based on race in which basically if you were black you were marketed a subprime mortgage regardless of whether or not your credit score merited that.
For sure.
So I think in a lot of cases we haven't seen widespread abuse of this because the people who are getting set up to be abused are very young. I mean, they're 10, 11, 12 years old. They're not going for credit yet. They're not going for mortgages. But over time, as these records are collected, maintained, and really don't go away, and I'm concerned about the breach piece.
Federal education records wouldn't be under the current law, right? Wouldn't be allowed to be used for purposes of mortgage.
But this is there are two things that are happening in parallel. One, the idea of what a federal educational record is being bent out of beyond recognition in a lot of tech, ed tech vendors' terms of service. And second, there's also a lot of work going on within big data companies to create profiles that parallel FICO scores but aren't regulated in the same way. So you have marketing profiles being created based on behaviors which are not regulated by law but which are being increasingly used to determine who gets offered what services, who gets offered what products.
Or at what rate.
Yeah, exactly.
For sure, but do we know that that education records are being used for that? Because I thought then that they would have to register as a credit agency under the, even for these weird, bizarro sort of credit score like things, you're supposed to register as under what is it?
The FCRA. I mean,
Yeah.
it could be, but they would have to be a credit reporting agency.
We gotta let them go.
But I think our panelists are available after. I just want
Yeah,
to
because they're so polite. They don't want to get up and walk out, but they really need to. So
So thank you again to everyone on the panelists.